Hi, my name is Hannah Waller. I am representing Joe Biden's new transitioning administration, and I will be representing the policy in civil rights. So today we will be covering some cases and some ideas, some topics that will help push Biden into the great direction that he needs going into this next year in this new presidential term. How I plan to help Biden transition into his new presidential term is by evaluating the American legal system through civil rights. So we'll go over the roles that courts play in civil rights, which covers the important cases, the settlements, the attempted litigations, the different factors in response to the court interventions, the decisions made, followed, challenged, and disregarded. We will also look into what's accepted, the progress, the strengths, the weaknesses, the controversies within these cases. Next, we'll look into the vulnerabilities in American courts by looking into what challenges their legitimacy, their power to persuade. Do these policy conflicts exemplify an American judiciary system that stands strong? Followed by looking at what do these policy stories tell us about the adherence to the rule of law. Do the norms of the court opinion and judicial actions, are they followed, or even if we don't agree with them? And lastly, I would just put excuse me, lastly, I will talk about my recommendations for the Biden administration to secure the integrity of the American legal system, because over the years, it's been a little toyed with, messed with, and we really need to make sure that there's a strong foundation on the American legal system that we stand on. First and foremost, it's important to understand that we know what the Civil Rights Act of 1866 exemplifies and understands that it has brought us to where we are today. So civil rights is the rights against African Americans or people of color. Numerous rights include, the right to be sued in court, to testify, or to give evidence in a suit filed by someone else to purchase merchandise or property. Initiated in 1960, the civil rights movement is known to be the most important event on the United States timeline. And the American leaders and activists like Martin Luther King, Malcolm X, and the infamous Black Panthers stood up for the rights of African Americans that they didn't have, as they were treated as half of a human and not as a whole human. Followed by race riots that can be mirrored in times that we live in today, with peaceful protesting that's been turned into violent protesting and looting, and, just more tragedies that we hear every day on the news against African Americans in the community that we've established, being here in America. This movement is against discrimination, inequality, injustice, segregation in society based on race and ethnicity. And this Civil Rights Act basically is what keeps us in America today. So what comes to my mind when looking into the policy of civil rights, there's 3 court cases that come to my mind. The first one is Shelley versus Kramer. Kramer and other white property owners governed by restrictive covenant brought in Illinois state court seeking to block the Shelley family, who were an African-American family looking to own property. The Kramers essentially did not want them to be there. They were a white family, they were in a white neighborhood, they did not want to bring in any minorities into the neighborhood, so they tried to block them for that. We will be looking into that case later. Next, we have the most influential cases within the lifetime that I will ever live in today, is the Brown versus Board of Education in Topeka, 1954. This situation occurred when an 8-year-old African-American girl named Linda Brown was denied permission to go to elementary school, which was 5 blocks from her home in Topeka, Kansas. The school refused to register her, while the separate elementary school for whites and non-whites were maintained by the Board of Education in Topeka. Brown's parents filed a lawsuit to force the schools to admit her to the nearby but segregated school for white students. So we'll be looking into that case more too, answering all the questions that we will evaluate within this system. But The third case that we'll be looking into is the Regent of California versus Bake. Alan Bake filed a suit after learning that minority candidates with lower qualifications had been admitted into medical school under a program that reversed spaces for disadvantaged applicants. So you know how some schools will have some slots reserved for minorities or those in a position where they need a little bit more help, a little bit more assistance. So that's what those spots were reserved for. However, he is suing after learning that they have lower qualifications. Affirmative action was unconstitutional in this case, where affirmative action program was used in a quota system. So we will be also looking into these 3 cases while evaluating them at the same time. First, looking into the roles that courts played in all 3 of these. So in Shelley versus Kramer, justices ruled that a court may not constitutionally enforce a restrictive covenant that prevents people of a certain type of race from owning or occupying property. The 14th Amendment prohibits discrimination by state action, but in this case, the individuals who agreed in private not to sell property of member of certain races. The plaintiffs, lost that trial, but on appeal, the Missouri Supreme Court reversed and ruled that the agreement was effective and it did not violate Shelley's constitutional rights. Now, the roles that courts played in Brown versus Board. For Linda, led by NCAACP litigator, argued that the operation of separate schools based on race was harmful to African American children. An extensive testimony was provided to support the contention that segregation resulted in both unequal education and low self-esteem among minority students, and it was implied that African American students were inferior to whites, which creates an toxic learning environment for everyone. It makes children who don't even understand what's going on in the world feel like they're less or beneath because of the circumstances that are granted outside of their control. Lastly, in Regent of the University of California versus Bake, the court did not prohibit the school from considering race as a factor in the future admissions decisions. 4 justices agreed with the conclusion as of to Bake individually, and the 4 other justices agreed with the ruling as of to use race information in the future. Justice Powell, who was a part of the court decision, wrote that the guarantee of equal protection cannot mean one thing when applied to one individual and not something else when applied to a person of another color. Second, now we're going to look into the different factors in response to the court interventions, starting with Shelley versus Kramer, 1948. The factors in this case is the individuals who had privately agreed to not sell property of people in a certain race, and the fact that the contract was private. The plaintiff in the litigation had sought the assistance of the state court and enforcing the contractual provisions. The undisputed facts disclose that the petitioners were willing to purchase the properties upon which they desired to establish homes. The owners of the properties were willing sellers, and contracts of the sale were accordingly consummated. Excuse me, my dyslexia is driving me crazy. I'm really nervous. But basically, because this conversation had been had in private about how they did not want this African American family to be had in their neighborhood, and not necessarily written out on a contract on paper that was written that could be documented, used as evidence. The contracts of the sales were consummated. So, I mean, they initially had the right to not sell to them. Moving on into Brown versus Board, it was an unanimous decision, 9-0. The Chief Justice Warren wrote in that segregation in public education is the denial of equal protection of the laws to separate children from others of a similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely to ever be undone. The impact is greater when it has the sanction of the law for policy of separating the races. It's usually interpreted as denoting the inferiority that the African American group is a sense of inferior, and affects the motivation of a child to learn, also as it deprives them of opportunities that they would have in an integrated school system. This decision did more than reverse the Plessy Doctrine, but the separate but equal. It reversed hundreds of years of segregation practice in America, and it's truly one of my favorite court cases because it allows me to be here today. I love school, I love education. I couldn't imagine it being segregated. It just breaks my heart to know that there was a time that we lived in today where people, who look just like me, were not allowed to see the person who I live right next door to who is not my skin type. So it's just really mind-blowing to see how far we've come from today. Last, looking at the different factors in response to court interventions from the Regent of the University of California versus Bake. The California Supreme Court ordered the state-run University of California, to admit Blake, where the university appealed to the United States Supreme Court. The factors in the situation is that race could properly be considered and as an affirmative action program, which is a policy of taking positive steps to remedy the effects of past discrimination. Third, we're looking into the vulnerabilities in American courts, starting with Shelley versus Kramer. For the active intervention of the state courts, they were supported by the full panoply of the state power petitioners, who would have been free to occupy the properties in question without restraint. Accordingly, state judicial enforcement of restrictive covenants based on race denies the equal protection of the laws in violation of the 14th Amendment. In Brown versus Board, a reverse Plessy versus Ferguson separate but equal ruling, which is known as segregation in public education, is a denial of the equal protection of the laws. The integration of labor unions in the 1930s under the Fair Employment Practices Commissions and the desegregation of the armed forces by President Truman in 1948, marking the major steps towards racial desegregation. The Brown decision is seen to be one of the biggest transforming events, or seen as the birth of a political and social revolution. Lastly, the Regent of California versus Bake. The legal impact of Bake was reduced by the disagreement among justices. Because the court had no single majority position, the case could not give clear guidance on the extent to which colleges would consider race as a part of an affirmative action program. What's most important to look at is, what do these policy stories tell us about the adherence to the rule of law? Well, in Shelley versus Kramer, years after this case, private discrimination in housing is now prohibited by Title 13 of the Civil Rights Act 1968, as well as by statutes in the most states, by ordinance in many municipalities as well. Eventually, in the 1960s and the 1970s, when residents in big cities are worried about the increase of racial diversity in their neighborhoods, it was alarming to white families to sell their homes to black families or homeowners. And so they used the sold sign tactic to alarm other residents to sell their homes as well, so that it could get basically one group of people in a neighborhood and another people out of neighborhood. Eventually, the sold sign was eventually banned. In Brown versus Board, in a later case called Brown 2, it was suggested that two decisions were to be made dealing with the constitutionally of the segregated, and the second with the implementation of the decision tells me that the court directed an end to end school segregation by race with all deliberate speed. What this tells us about adherence to the rule of law is that the Brown decision became the cornerstone of the social justice movement of the 1950s and the 1960s, and it brought the 14th Amendment into practice more than 3/4 of a century after the amendment had been passed. In Regent of the University of California versus Bake, affirmative action remains a controversial issue in California, and in 1996, voters passed the California Civil Rights Initiative known as Prop 209, which prohibited all government agencies and institutions from giving perfectio, excuse me, let me pronounce this word, preferential treatment to individuals based on their race, gender, while being in the Supreme Court. The Supreme Court also refused to hear an appeal from a decision upholding the constitutionality of the law. So my recommendations for the Biden administration to take to secure the integrity of the American legal system, I see it as, under the Biden administration, there will be a new movement in power of the government, and where we hope it mirrors the authoritarian policies that were in place under the Obama administration. My true recommendations for the Biden administration to secure integrity of the American legal system is to first get Biden to sign the Equality Act into law if it is passed by the Senate. This legislation limits the religious freedoms by uplifting the LGBTQ rights, which can take precedence over other rights. The Equality Act amends the 1964 Civil Rights Act to prohibit discrimination on the basis of sex, sex orientation, or gender identity. Second, I find it important that he restores the Affordable Care Act, forcing religious ministries, schools, along businesses operated by religious devout owners to cover the insurance costs of birth control drugs that could cause abortions. Third, he should focus on the overdue criminal justice reforms that can reinforce the bold changes in local prosecutors that they are having in the communities around our nation. And last, if he can create an environment in this United States that creates a feeling of uniform inequality, because over the last 4 years there's been an uproar of inequalities, and the more we can make the United States feel more united, maybe a better America we will live in. Thank you so much for this opportunity, and I am thrilled to see what Biden has in store for us in the country that we live in for the next 4 years. Thank you.